Hello, fellow seekers and everyone. I hope you all are doing well. Here, I have, there. No, kidding. The documents, the order on defendant's motion to suppress defendant's statements at OCSO, on defendant's amended motion to suppress defendant's statements at OSCO, and on defendant's second amended motion to suppress defendant's statements at OCSO. So, hi, if you're new here, I hope you find this a warm and welcoming place. It's a very laid-back, unprofessional-like environment, but I do try to do my research the best I can and try to be lighthearted, even though these situations are not lighthearted, but I always feel like you have to find some humor in something. So, and I'm not a psychologist, psychiatrist, lawyer, paralegal. As I always say, just someone who's interested in true crime and finding justice for the victim and family, which at this time is George Torres and his surviving family members. So, with that, let's get on with this. I know this can be kind of like, but some of it is actually kind of interesting. So, all that case law, I'm not going to read all of that, but it'll say, I'm starting in the court having reviewed the motion, having reviewed the response, having reviewed the amended motion, having reviewed the second amended motion, having reviewed the court file, having considered the testimony and evidence offered by the parties, having considered the arguments offered by counsel for state, and having considered the arguments offered by counsel for defendant, finds as follows. A. Defendant Sarah Boone is charged by way of an information filed 3/23/2020 with a single count of second-degree M. On February 24th, 2020, defendant called 911 after finding her boyfriend, George Torres, deceased. C. Deputy Kayla Rodriguez arrived on February 24th, 2020, and spoke to defendant. C. also states Exhibit 1. D. Detective, I think most of them are calling her Copsel. I said Copsel, but I get whatever. We can say Detective K even. I gotta just stop for a minute and say, by the way, guys, man, I thought she was stunning. I mean, on the 4 years ago, of course, she was with child, and I think she was sick because she was coughing, and I thought she looked stunning. I really did. And I kind of liked her attitude because probably, her and like Mr. J and Mr. Cacciatore, I mean, this has been going on for 5 years. They're probably tired of it, so I'd probably have some attitude too of all this holdup due to who. Anyhow, I just had to say that. So Detective K, a homicide detective with the Orange County Sheriff's Office with 6 years experience as a homicide detective and a law enforcement officer since 2013, was the lead investigator of George Torres's D on February 24th, 2020. Detective K arrived at the scene within 30 minutes to 1 hour of OCSO deputies arriving, was briefed, and performed a walkthrough of the apartment. Thereafter, a search warrant was drafted. I think I'll go ahead and move this, up. There we go. E. Detective K then made contact with the defendant outside of the apartment for a few minutes and explained procedures of the search warrant. The search warrant was executed with CSI. Defendant's cell phone was collected after CSI documented the scene. Detective K wanted to go through defendant's cell phone to corroborate defendant's story. Defendant signed a consent prior to the February 24th, 2020 interviews addressed below. Detective K did not look at defendant's cell phone, including any videos prior to the interview addressed below, as digital forensics did not arrive until approximately 7 p.m. Detective K then made contact with defendant's ex-husband, Brian Boone. Thereafter, Detectives K and Lowen had an interview with defendant and Detective Copsel's unmarked Nissan Pathfinder at approximately 5 p.m. See also states Exhibit 1. Detective Copsel, or K, whomever, explained that she wanted to have conversations with the defendant after walking the apartment. Detective K testified that she would not have interviewed defendant outside of the unmarked vehicle, but had no memory of using the words routine, and that everything was explained on the recording. The word routine is not used by Detective K in any recording, and that's another exhibit. And I did happen to find I think that's one I did not post, her interrogation in the car, the first interrogation you could call it, and there is nothing that not that it's a big deal, but it does kind of corroborate that Sarah maybe was not being truthful. There's nothing about routine said. F. Detective K explained the purpose of this interview, including defendant's prior conversations with Deputy Kayla Rodriguez and Detective K, and Detective K's desire to get a further understanding of what happened last night and ask the defendant more detailed questions. Thereafter, Detective K began reading Miranda as follows. I'm going to read you your rights, but it's just because that's how we do things, okay? So you do have the right to remain silent, okay? Do you understand that? And there's a little part let me show you. Right down on the little print it says, all 8 questions on Detective K's Miranda card were read, as Detective K's Miranda card did not have question 9. Okay, so she's saying, do you understand that? And defendant says, yes. Detective K, anything you say may be used against you in court. You have the right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one, one can be provided for you before question without charge. Has anyone threatened you or promised you anything to get you to talk to me? Defendant, no. Detective K, do you understand what I just read to you? Defendant, yes. Okay, now we're on G. Thereafter, Detective K interviewed defendant again after the initial digital recorder memory was full. A second separate recording was initiated. Detective K confirmed with defendant that no additional communications occurred prior to the second separate reading, and Detective K inquired of defendant prior to asking any other questions. You do understand that you don't have to speak with me if you don't want to, correct? To which defendant responded yes. After concluding the interviews, but before leaving, Detective K had conversations with defendant. Oh, the way it's written here or typed here. K had conversations with the defendant. Conversations, the way it's typed here, so sorry, with defendant about coming to OSCO the next day to address the pending autopsy, and that Detective K would have more questions. Detective K did not recall speaking about defendant's cell phone, but had defendant asked about getting the cell phone back, Detective K would not have given a specific time frame for returning defendant's cell phone. Detective K had no memory of receiving a call from defendant on the evening of February 24th, 2020. 1. Defendant's testimony largely agreed with Detective K's testimony, including the timeline of calling 911, speaking with Deputy Kayla Rodriguez, and speaking with Detective K. As to the February 24th, 2020 interviews, defendant confirmed that Detective K explained that general questions would be asked. Defendant confirmed that she stayed on the scene 10 plus hours while the investigation was performed. Defendant's own testimony was that she was under the influence of alcohol from the night before at approximately 1 p.m. the next day. However, there was nothing evidencing defendant being intoxicated or under the influence of alcohol when clearly speaking and interacting with Deputy Kayla Rodriguez. I want to read that one thing up there before we move. Hang on. All it says is, doing this second separate recording, defendant used higher tier words, including compos mentis. Oh, that's right. So they're trying to say, remember how she used that fancy word compos mentis, which is having your wherewithal, knowing what's going on, which is, the more she speaks, the more she messes up herself. So if she was able to say that word, I think what they're trying to say is they don't believe that she was impaired by the alcohol. Okay, so letter J, defendant's statement of making a call to Detective K between 9:30 p.m. and 10 p.m. on February 24th, 2020, from her ex-husband's home does not line up with defendant's own timeline of staying at the scene 10 plus hours, which began at approximately 1 p.m. The court finds this statement lacks credibility. Oh, man, Sarah. K. Defendant claimed that before they left the scene, Detectives K or Lowen would return defendant's cell phone to the apartment. On February 25th, 2024, defendant claims the defendant and Detective K had a discussion regarding the picking up of the defendant's cell phone, specifically that due to Detective K's pregnancy, defendant needed to come down to OCSO to pick up the cell phone. Defendant's sole reason for traveling to OSCO was to pick up the cell phone. The court finds defendant's statement regarding picking up the cell phone also lacks credibility. So, one, on February 25th, 2020, after Detective Kopsel, or K, or Kopsel, reviewed some of the extractions of defendant's cell phone by digital forensics and attended the autopsy. Detective K requested defendant to come to the OSCO's office. Detective K did not want to approach defendant in front of her child at her ex-husband's home. Now that makes more sense than the other thing. Defendant's worry and concern about her son was addressed with Deputy Kayla Rodriguez and the dogs. Poor dogs. M says, the state and the defense agree that the February 25th, 2020 interview was custodial. N. The pith of defendant's argument is contained in this exchange during the beginning of the February 25th, 2020 interview. Detective K. Just let us know if at any time you need water, okay? I'm going to have you sit in the green chair. Detective K. Appreciate you coming in. Defendant. Yes, ma'am. I want to ask about these when we have a moment, referring to her prepared written questions. See, if she brought questions, she did not think she was not being coerced. I don't think she felt any fear. I think towards the end she started realizing, the more she talked, she was like, well, maybe I shouldn't have said that, but too late, Sarah. Anyhow, Detective K, sure. So obviously he received his autopsy. So I'm going to read you your rights again because we have to talk about that. And since I'm talking about the incident, we just have to do it, just like we did yesterday. Defendant, normal protocol. It wasn't in there. Anyhow, Detective K, just like we did yesterday. Remember, I read you the rights. Defendant, yeah. Detective K, yeah, it's the exact same thing, but since I'm asking you follow-up questions, I need to read them to you, okay? Defendant, sure. Detective K. All right, so you have the right to remain silent. Anything you say may be used against you in court. You have a right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one can be provided for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk with me? Defendant, no. I wanted to read this little thing right up here. All these little things are kind of interesting. Right up here in this area, it says, approximately 1 hour and 27 minutes into the February 25th, 2020 interview, defendant returns to her list of prepared written questions and specifically asks, am I going to get my phone back? See States Exhibit 1. The prepared written questions would not be asked if one were told to come pick up cell phone. See? Oh, Sarah, things are not looking good for you, girl. Okay. So here this little thing is. It says, oops, let me pull up a little bit. I'm sorry. The court notes that this statement is an accurate statement of the law. See Wright versus State. While I was talking about this is in the case law. Well, Detective Stroup said, this is something I have to do. When giving the Miranda warnings, this is an accurate statement of the law, as law enforcement officers are required to administer Miranda rights prior to custodial interrogations. And I can also tell you, when I went back and listened, it wasn't like Mr. Owens had said, I have to talk to you. You'll see. I'll try to play that. But it wasn't like that at all. Can't blame him for trying, though. Detective K, and do you understand what I just read to you? Defendant, yes. See States Exhibit 1. Okay, so it's like, says whether the Miranda warning is sufficient. I think they left some words out. Okay. Oh. The Fifth Amendment of the United States Constitution and Article 1, Section 9 of the Florida Constitution both provide for a right against self-incrimination. The self-incrimination class of Article 1, Section 9, Florida Constitution requires that prior to custodial interrogation in Florida, suspects must be told that they have a right to remain silent, that anything they say will be used against them in court, that they have a right to a lawyer's help, and that if they cannot pay for a lawyer, one will be appointed to them. Both the Florida Supreme Court and the United States Supreme Court have stressed that there is not talismanic incantation required to ensure the Miranda warnings are sufficiently covered. A court does not examine a Miranda warning as if construing a will or defining the terms of an easement. Let me just pull this up a little bit more. Okay, so it's right here. The crucial test for determining whether police gave a proper warning is whether the words in the context used, considering the age, background, and intelligence of the individual being interrogated, impart a clear, understandable warning of all of his rights. The Miranda warning provided by law enforcement to defendant at the beginning of the February 25th, 2020 interview is sufficient over both federal law. Quoting, let me see, okay. Yes, all this case law. Okay, and then the little words in the bottom here. In 1966, the United States Supreme Court issued its opinion in Miranda and established 4 warnings that are required prior to questioning when a person has been taken into custody or otherwise deprived of his freedom of action in any significant way. Specifically, a suspect must be warned prior to any questioning that he has the right to remain silent, that anything he says can be used against him in a court of law, and that he has the right to the presence of an attorney, and that if he cannot afford an attorney, one will be appointed for him prior to any questioning if he so desires. So it sounds like Detective K did cover the bases based on what they're saying here. R, the Miranda warning given to defendant in the instant case is identical to the exemplary Miranda warning identified in Owens. Interesting name, that's Owens, right? S, as such, the Miranda warning given to defendant in the instant case was sufficient. Now we get to whether the defendant's statements on February 25th, 2020 were coerced. Okay, T, to establish that a statement is involuntary, there may be a finding of coercive police conduct, Baker versus State. Generally, to determine whether a confession is involuntary and coerced, a court may examine the totality of the circumstances surrounding it. When the voluntariness of a confession is in dispute, it is the state's burden to prove voluntariness by a preponderance of the evidence. Let me go ahead and pull this up. There was no misrepresentation of the law regarding any defense. No quid pro quo. No directly or specifically made promises. No overt act or threat of force against defendant was proved or claimed. No fear of material or physical harm. No hope of material reward. No indication that defendant was a newcomer to the law based on the 2 times Miranda warnings were provided between February 24th, 2020 and February 25th, 2020. No indication that defendant is mentally deficient, especially considering the verbiage she used, the one I read above. No threats, delusions, deceptions, or promises, and defendant was offered water and breaks. Well. Okay. V, there were no false statements made by law enforcement in order to coerce defendant to go to OCSO's office on February 25th, 2020, based on the findings above. W, under the totality of the circumstances, defendant's statements on February 25th, 2020 were not coerced. Of course not. She was spilling her damn guts. Okay. Whether the defendant's statements on February 25th, 2020 were voluntarily made. X, a statement is not compelled within the meaning of state or federal law if an individual voluntarily, knowingly, and intelligently waives his constitutional privilege. The state must prove by a preponderance of the evidence that a defendant's Miranda rights were waived. To constitute a voluntary waiver, the state must show, 1, that the waiver was the result of a free choice on the part of the defendant and not the product of intimidation, coercion, or deception, and 2, the waiver was made with a full awareness of the nature of the right being abandoned and the consequences of the abandonment. Only if the totality of the circumstances surrounding the interrogation reveals both an uncoerced choice and the requisite level of comprehension may a court properly conclude that Miranda rights have been waived. Y, factors relevant to consider include 1, manner in which the Miranda rights were administered, including any cajoling or trickery. 2, the suspect's age, experience, background, and intelligence. And 3, the fact that the questions took place in the station home. And 4, the fact that the interrogators did not secure a written waiver of the Miranda rights at the outset. Z, the Miranda rights were administered. Let me pull this up. The Miranda rights were administered in a normal tone and cadence. There was no rushed or urgent speech. There was no delay in the administration of defendant's Miranda rights. The recorded February 25th, 2020 interview reflects that defendant understood and acknowledged that she understood her rights. Defendant acknowledged she understood her rights. Okay. Evidence supported conclusion that defendant voluntarily waived right to remain silent and obtain counsel when officer read she is defiant, but in this case, defendant, his rights and asked defendant whether he understood each of the rights, to which defendant responded affirmatively. AA, the court reincorporates its findings in herein, which further show no cajoling or trickery. BB, defendant was 42 years old at the time she made the statements and appears to be of normal intelligence. Oh my gosh, couldn't you just see her wanting Mr. Owens to file a motion about she's of normal intelligence? Oh boy, let's hope they don't do that. I mean, it wouldn't, I'm just being silly, but could you imagine her being all mad about that? CC, the February 25th, 2020 interview did take place at the OCSO's office and no written waiver was secured. DD, under the totality of the circumstances, defendant's statements on February 25th, 2020 were made with a voluntary knowing and intelligent waiver, and the waiver was, the result of a free choice on the part of defendant and was not the product of intimidation, coercion, or deception, and that the waiver was made with full awareness of the nature and the right being abandoned. Orders and adjudges as follows. Number 1, the motion, that amended motion, and the second amended motion are hereby denied. Yes. I love that they were denied. Perfect. Okay. I know we keep coming back to this interrogation, but let's look together and see, review and see if Sarah looked like she was intimidated and coerced. I can't even say that word right. Forced, or you could say forced to say something she didn't want to. I mean, obviously, let's get real. If she brought her list of questions, I truly do believe she thought she was going to leave and get her phone. I do think she thought that. I don't think they told her that, but, Sarah has her own unique way of thinking. I'll say it nice like that. Let's take a look.
Okay. I'm going to have you sit in the green chair. It doesn't move. Appreciate you coming in.
Yes, ma'am. I want to ask you about these whenever we have a moment.
Sure. So obviously, he received his autopsy. So I'm going to read you your rights again because we have to talk about that. And since I'm talking about the incident.
Did you hear that? Because we have to talk about that. It wasn't like, we have to talk about that. Dreadful.
We just have to do it, just like we did yesterday. Just like we did yesterday. Remember I read you the rights? Your rights? Yeah. So it's the exact same thing, but since I'm asking you follow-up questions, I need to read them to you, okay?
Sure.
All right. So you have the right to remain silent. Anything you say may be used against you in court. You have the right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one can be provided for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me?
No.
And do you understand what I just read you?
Yes.
Perfect. Okay. So this morning we went to his autopsy. and we were informed of some injuries that he has by the doctor. So so he's got scratch marks to his back.
I know what that's from.
Okay. And it's called a contusion. Do you know what a contusion is? So, like, basically you're getting hit, and then, you get a mark from it. You'll get bruising. Like someone hit you or something like that. It's called a contusion. So he had some injuries to his left shoulder. He had a cut near his lip. We could see his mouth was a little
I haven't laid a
swollen.
hand on him.
Okay.
Also, too, he fell off my son's bike,
Okay.
so I don't know. And he's notorious for running into the wall or the hall tree. So
Okay. What about the scratches? Because there's also sex.
Yes.
Okay. Because there's also like a scratch on the back of his neck, kind of going, but it's going straight across.
I have no idea what that's from.
And they're all recent. They occurred recently. It wasn't something that occurred post or that occurred a week ago or 2 days ago, 3 days ago. They definitely occurred, the night leading up to when he was.
In all honesty, we have not gotten into it.
Okay.
That's why, the only thing I thought you guys were going to ask me about, which I was going to be honest with you anyway, are the scratch marks on his back.
Mhm.
Everything else, I have no idea what it is. No idea what it is. Nonetheless, I've had my son over the house too, so.
Well, your son was there when? When was he last there?
Oh gosh.
From my understanding, he was there last Tuesday.
I don't know if it was Tuesday, but yes, he was there last week. So.
Well, we're talking about Sunday. We're just talking about what occurred Sunday. Because, like I said, the injuries they occurred within that time period.
So you're talking about day before yesterday?
Sunday leading into Monday. You called us yesterday at 1, but the incident, you guys were painting and stuff the night prior.
Correct.
So we're talking about Sunday and then into Monday.
I'm thoroughly confused because we had a good time sitting on the back porch having wine and smoking a couple of cigarettes, and then decided to go inside and literally paint, do puzzles, and play.
Mm-hmm. See, she came in because, number one, she wanted to get her phone. Number two, she wanted to kind of feel them out, I think. And so, I forget who it was. Was it Peter from Lawyer or someone else? I watched so many different people, but they were saying it's almost like she's trying different things to things that will work the best to her favor. Because she'll say, I'm sure y'all remember this, she was talking about, we had a good day and blah, blah, blah. And then when she felt like things were getting kind of weird, she goes, you all don't understand. He comes at me. So it's kind of like back and forth. That's not going to look good to the jury because she's switching back and forth, back and forth. And now that the judge is going to allow this into evidence, it's going to be even harder for her to prove battered spouse or self-defense. Not to say that she wasn't, because of course I will say every day, all day long, that they both were guilty of hurting one another. But to the degree that she did, she keeps portraying this picture that it was all fun and games and la 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 and, kumbaya, all that wonderful stuff. But it wasn't. And then I was thinking of some other things while we're talking about it, is that remember, she had spoken, they said they had spoken to George's kids. I think he has 2 daughters. And yes, I do remember, because in the car interview, which maybe I'll put in a link below for y'all to listen to that if you haven't, there were things that I hadn't heard from that one. Like talking about, I think he has 2 daughters, and then he has a son, and I think he's I don't know if he was mentally or physically challenged, but I think it was George Jr. That just makes me feel really sad. I don't know, it's kids, but things that will not corroborate with what she's saying about it's all great. If you remember the interview, which I did play with Juan Torres, George's younger brother, he said that George called him around 7:30 that night, and he said George sounded calm. Now, maybe he had been drinking, but he says usually if George is really intoxicated, he gets real excited and is just very animated. I don't know if he's necessarily mean, but just very animated. But he was very calm, and he was talking to his kids and teasing his kids, talking about Juan Torres, because Juan and his wife and his children were playing dominoes or something like that, and that George was calm. But then Sarah started yelling in the background, saying that she has to call her brother, and that, she wanted George to get off the phone, yada, 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 all that kind of stuff. So you could see that already, at least Sarah was in a heightened state of agitation. And sounds a little like she was turning into the feral chihuahua that we all know she can be. And remember, George's brother Juan did say they have hit each other. And of course, she was yelling on that same phone call I'm talking about now. She says, I'm going to tell him about your choking me, blah, blah, blah. And Juan also said, because I was listening to the interrogation of him again, that George would leave. Sarah would tell George to leave. And so I guess she would take him to, I don't know, wherever, his parents' house or somewhere. But then she would call and want to come get him. So I almost feel like Sarah was the alpha person in the relationship. Could be wrong, but I really do. And Juan also was talking about how Sarah was a big wedge in between the family. And you remember how she said that that she had kind of pushed not her dad, but Mr. Torres, the father of George and Juan, pushed the dad. Remember, she was kind of physical with people, because remember, all the people were talking about they're uncomfortable with her touching and all that kind of stuff. And what was the other thing? And he also said that she had hit George with the phone a few times. Now, he said Sarah had bruises too. He wasn't saying that George was totally innocent. So, and he always said she always sounded crazy. And that she seemed like she was the one who was the instigator. She would always be the one who started yelling. And the one thing I noticed from the car interview also, that she started talking about that George was losing his teeth. And she wondered, and he had complained at one time about chest pain. And she was wondering if that was connected. Because, if you do have dental problems, that can connect to the heart if you have an infection or something. So I don't know if she was just grasping for things or something like that. Because remember, she said, I wonder if he had an aneurysm. I don't know what happened. We're all like, you fool. You zipped him in a suitcase. What do you think happened? But that's some of my thoughts on that. Okay, this is the car interview. I wanted to just play a little bit of this. And what I'll do is, this comes from Deep Dive True Crime and Mentor Lawyer. And I just wanted to play the very beginning so you could hear that Detective K did not say anything about normal protocol or whatever, like Sarah had said she did. And I think the judge had also said in his paperwork just there. Okay, here we go.
It is February 24th, 2020. The time now is approximately 16:57 hours. This is in reference to Orange County case number 20-017904. I'm currently located in my unmarked vehicle out in front of 4748 France Lane, apartment number 3 in Winter Park, at the Tealwood Park Apartments. And also in the car with me is my partner,
Detective Scott Lowen.
And in the front seat is, can you state your name, ma'am?
Sarah Boone.
Okay. Okay, and your birthday?
10/10/77.
Okay. So, Sarah, I know you have talked to some deputies. I know we had a very brief conversation just to reiterate what you told that deputy. But like I was explaining, I would like to get a more further understanding of what happened last night and ask you more detailed questions. I am going to read you your rights, but it's just because that's how we do things, okay? So you do have the right to remain silent, okay? Do you understand that?
Yes.
Okay. Anything you say may be used against you in court. You have the right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one can be provided for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me?
No.
Do you understand what I just read you?
Yes.
Okay. So
there you go. Nothing was mentioned about normal protocol or whatever. So, a lot of strikes against her. That's not going to make her look good at all. They have like a complete, I think, playlist of the of her interrogations. And this one is very interesting because, like I said, that's how I learned about George's children. And I'm just trying to think if there's anything else. I guess not. I always try to write down everything. But those are just some things I think is interesting. Obviously, that night she was annoyed because it was only 7:30. And allegedly the suitcase thing began like around 11 p.m. So she had all this time to get inebriated and become the rabid chihuahua. So we know she was agitated. Now, I don't think he was as agitated as she was. And so how are they going to prove that he did something? I don't know. I think it's going to be a hard thing, but let's face it, it will be interesting. I just hope that George can get justice and his family can have some closure. Okay, here is the other thing that the state filed. The motion, it says order granting state's request for protective order. Remember how they were talking about wanting to bring in all these people connected to the state that maybe didn't even have anything to do with Sarah, maybe just processing information, wanting to come in as witnesses. And so it looks like it's another win for the state. It's saying this cause came before the court on October 2nd, 2024 on the state's request for protective order e-filed on September 30th, 2024, the request. The court, having reviewed the request, having reviewed the court file, having considered the arguments offered by counsel for state, and having considered the arguments offered by counsel for defendant, hereby orders and adjudges as follows. There are other legal avenues to present the evidence that are available to the defendant that do not infringe on work product. See Egan versus Demonio. The request is hereby granted. So that's 2 for the state, 0 for the defense. But wait, there's more. Okay, so there is, where did I find it? Oh, right here. Order granting, let's see, it's comments. Defendant's motion for a right to hair, cosmetics, and civilian clothing without restraints for trial sent to dockets. So we remember now, Sarah, she's not going to be able to do the makeup. I'm telling you, she was annoyed by that. And I feel like the reason why so far her and Mr. Owens are getting along, other than that time they were yelling, is that he just goes on, whereas the other attorneys wouldn't do it. He's just like, what do I have to lose? I got to give him, he's got the gonads to go on and ask for this stuff that probably did you see Cashman saying, no, you're not going to have a hairstyle. I don't think she's going to get that if they can't do the, I don't know, maybe they will be able to. Okay. I think, though, if I'm not mistaken, this is a part win for the defense because I don't think that Sarah will have to wear any restraints. Now, they already figured out, they had already determined a while back, several hearings back, that Sarah would not have to wear handcuffs. But I thought the last thing I had heard, but that was again when she was defending herself, that all she would have to do is wear that little shock device around her ankles. But I think, don't let me jump the gun. Let's see here. Okay. Order on defendant's motion for a right to hair, cosmetics, and civilian clothing without restraints for trial. This cause came before the court on October 2nd, 2024 on the defendant's motion for a right to hair, cosmetics, and civilian clothing without restraints for trial, E-Fide 927-2024, the motion. The court, having received the motion, having received the court file, having considered the arguments offered by counsel for state, and having considered the arguments offered by counsel for defendant, finds as follows. A. The court provided an or terms ruling on October 3rd, 2024 regarding defendant appearing in civilian clothes for trial and defendant's access to cosmetics and hairstyling throughout the trial. B. The court reserved ruling on defendant appearing before the jury free from physical restraints. I feel like, well, let me see here. Okay, so reserved. Okay. C. In deciding whether to physically restrain a defendant and what method to use, the court must balance its obligation to maintain courtroom safety against the risk that the security measures may impair the defendant's presumption of innocence. D. A court may order physical restraints only if it is found to be necessary to maintain the security of the courtroom. Before ordering a defendant shackled at trial, the trial court must make a case-specific and individualized assessment that considers, number one, the defendant's criminal history and the nature of the pending charges, with special attention to whether either involve violent acts. 2. Whether the defendant has disrupted criminal proceedings in the past. And 3. Whether the defendant has engaged in any threatening behavior. E. There was no evidence that the defendant has any criminal history. F. Defendant is charged by way of an information filed 3/23/2020 with a single count of second degree M. G. There was no evidence that defense has disrupted criminal proceedings in the past or been a continuous defendant during court proceedings. H. There was no evidence that the defendant has engaged in any threatening behavior. Orders and adjudges as follows. The motion is, The motion is hereby granted. Defendant's shackles and handcuffs be removed during trial proceedings. All right, so there's a win. She doesn't have to have any shackles or handcuffs. All right, but I think we already know about the makeup. Well, the clothing, that's another win. She will be able to be measured and have clothes, but I don't know if they're going to be able to do the hair. The makeup thing, you could tell she was disappointed about that. Hopefully she will have gotten over that by now. Okay, so we're going to do a comparison here. Because I know, like everybody's talked about it, there's the Sarah Boone, whom I call, when she's talking in her actions, she's like a rabid chihuahua. And then there's the Sarah that's like this, just like when she's recording, going, oh, if I may please, and thank you. She has that little, like a little girl voice, and it's just so annoying. Remember, I can have opinions because I'm not a lawyer, paralegal, psychologist, psychiatrist. So that's the beauty of being able to have opinions, right? But just listen to her for a minute.
Hey, would you please state your full name?
Sarah Boone.
Well, you have to speak up or move the mic.
Sarah Boone.
Yes. Where are you currently housed?
At the Orange County Corrections Department.
Have you been there since February the 25th of 2020? Was that the date of this interrogation that we're here for on this motion?
Yes.
All right. Let me take you back to the morning of finding George Torres in the suitcase. You called 911?
Yes.
Is it true that Detective or Deputy Kayla Rodriguez of the Sheriff's Department arrived?
Yes.
What mental state did you have at that time?
I was very confused.
Please.
It was very hazy. I didn't understand the monumental amount of people that were there, and
The monumental amount of people that were there? Really? Was it because usually when there is an incident or alleged crime, there would be people there? Oh my God. She's being dumb, innocent Sarah here.
what they were doing with my home. I was worried about my dogs. I was worried about my son. I was in shock. I was traumatized by the situation, and then trying to focus on everything that was going on at my home. I was hungover. I was still, I believe, intoxicated to a degree.
Please, girl, please stop right now. Stop. Anyhow, there's little innocent Sarah. And you can notice, I think I even commented on this when she and Mr. Owens, when he was questioning her, you could tell they'd been rehearsed, because she said, what is it about the Miranda rights? Oh, but number 9. Now, she didn't know what number 9 was at the time. Come on. Okay, and let's see how suddenly she doesn't, with her, well, we don't want to say normal intelligence in front of her, because she's going to be mad about that. But anyhow, she's going to, she was confused and all this stuff. And now when the state, which I love, asks her questions, she's a little different in knowing the answers, I should say. She really has quite a smirk, doesn't she? Even when she's trying to be all soft-spoken.
So that afternoon on February 24th of 2020, when Deputy Kayla Rodriguez arrived at your residence shortly after 1 p.m., you were under the influence of alcohol, correct?
Yes.
You were impaired by alcohol, correct?
I don't know as much as impaired means. It did affect, yes.
Okay. And that was consumption from the night before, correct?
Yes.
So you did not go to brunch that morning and have mimosas or anything else to drink, correct? And you consumed no alcohol in your home that morning, correct? So does that affect in any way your memory when you testify about the events that transpired between you and Detective Copesel that afternoon?
One more time, please.
Did the alcohol have any effect on your memory of what happened between you and Detective Copesel that afternoon?
Now or then?
Then?
Come on, Sarah.
Did alcohol affect my conversation with her?
Oh, my Lord.
There's a jury instruction that says a witness's memory and perception is pertinent, and I'm asking you, did the alcohol that you were under the influence of affect your memory or perception of the events that you've testified to today that you said happened on that afternoon of February 24th, 2020?
So did they affect
My God. Come on now.
my answer?
Judge, I don't think she understands.
I don't.
Okay.
It's been asked 3 different ways.
So we'll leave it at you were under the influence of alcohol that afternoon, correct?
Judge, I think she said she doesn't know what. She said that she had alcohol under the influence or impaired.
The objection is, the court does not entertain speaking objections. The legal grounds need to be provided. What are the legal grounds of your objection?
To get out. But the video shows him attempting to get out, begging to get out, and he can't. So that's just what we're trying to figure out. I don't know if maybe you had too much to drink, you zipped it up all the way, and then,
I did not zip it up all the way.
Okay, well,
I did not zip it up all the way. This is horrific, okay? Horrific.
it is terrible.
Yeah, somebody else.
Horrific. I don't think I'll ever be right because of this. Ever be right. Dealing with everything else that I have in my life, personally.
In my
And then
life.
this,
Okay.
whom I loved, it was not intentional. I will put my hand on the Bible. It was not intentional.
How's that going to work with everything that Mr. Owens is trying to do?
I would not do that to him nor anyone else.
But you did.
Not intentional.
You intentionally went up to bed.
I didn't
Intentionally
intentionally
left
go to
him.
bed because I'm thinking, okay,
Hold
good,
on,
he can
hold
get
on.
out.
How did you not intentionally go to bed? You said you went upstairs and got into bed. That's intentionally going to bed.
Waiting for him.
And he doesn't come, but you don't go down to check on him.
So I happen to go to sleep. When I say go to sleep,
And what do you
goes
normally
off
do when you
whatever
go to
you're
bed?
gonna do.
What do you normally do when you go to bed?
What do you mean?
What is a bed for? Going to sleep.
Right.
So you go to
But
bed to
obviously
do
you
what?
can tell too that, like, I've
You
been
go to
drinking
bed
also.
to do what? Okay. You kept telling us, hey, I wasn't intoxicated. I wasn't this. I wasn't that.
Being drunk and intoxicated, which, yes, you can tell that I had been drinking, but
Okay. So if you weren't intoxicated, then why would you ever leave somebody in a suitcase that's begging to get out, that's telling you they can't breathe?
if I hadn't been drinking, you still think it would be the same thing? Where it's like, hop in, I'm gonna go to sleep. Is that what you all are trying to do? To
We're
portray me
not trying
as?
to do anything. I'm simply asking you
She's
to explain to me
portraying her own
what
self.
happened.
Everything was fine and dandy.
Fine and
I don't
dandy.
call it
Everything
fine and dandy.
was fine and dandy.
Explain
You
to
all
me.
don't, okay, for me to tell you this, again, mind you, I've been without him for a day now.
Mm-hmm.
I don't,
Don't you love how Detective K just puts on, I might have said this before, putting on George begging for his life while Sarah's blathering on?
know, I mean, I don't know what you all want me to tell you because this was not in any way, shape, or form, hand on the Bible, intentional.
Okay. So you just left
I
him there
didn't
to
kill
teach
him.
You left him there to teach him a lesson?
I didn't mean to leave him there. That's what I'm trying to tell you.
Oh, we're soft-spoken
You
Sarah.
walked away. How is that not intentionally leaving him there?
Because I'm looking at the hole, knowing that it's there. He'll get out no harm. Because you
And then
don't.
he doesn't,
But
so you don't go check on him. You say you're up for 30 minutes, and he doesn't come up. You don't go down and check on him?
I'm in the bed.
You even moved,
And goes
I mean,
off.
you admit to moving the suitcase, like, over. So
Roll it.
you roll it out, like, it's not like.
I didn't want him to be like that.
Is it, see, again, she's talking about it, moving
You
it.
want him to be upside down. How do you even get upside down?
Right. You guys are killing me right now.
I just want you to hear.
That's how he talks to me most of the time.
Now she's going to put it on him, of course. She always loves to do that. Deflect, deflect, deflect. This is why I can't with this woman.
I don't know how you want me to say it.
I'm just trying to figure out what you would expect to happen to somebody when you leave them in a suitcase.
I didn't mean to leave him in there.
Okay.
What's your reasoning for not calling 911 sooner?
Yeah, exactly.
I didn't know what to do and how horrific it was.
But she called her husband or
I
ex
called Brian,
first.
and like what, 5 minutes later I called you guys? Not even 5 minutes.
She waited for
Nonetheless,
Brian to
I had
get there.
I was trying to do CPR. I was trying to do CPR. I had to get him out and try to do CPR and then called you guys. And then was continually doing CPR with the dispatch on the phone where he had me count out loud to help me focus on what I was doing.
It just, I don't know how, I mean, you can sit here all day long and say, I thought he was going to get himself out, but he didn't, and you went upstairs, and you stayed there for 30 minutes before you fell asleep.
But can I say too, like,
You chose not to ever at any point during that 30 minutes walk back down and check on him.
no, wait 1 second, because I know, like, with you all, and then, like, because you continually ask me, like, time frames, where I told you, like, I don't bother even looking at the clock most of the time. So it's like a guesstimate. So for all I know, maybe it was 10 minutes.
Okay. But the point is, you left the living room where he was begging for help and went upstairs. Regardless of how long you were there, you left. You say,
I thought he was the boy calling wolf. Again.
Mm-hmm.
So when he asked to be let out, like, what's your reasoning for not letting him out?
When I was upstairs?
No, when he's asking on the video, he asked multiple times. He asked to be let out. I can't breathe. Why didn't you let him out?
Well, number one, I had no idea it was going to end like that.
Okay.
Number one.
Okay.
Number two, just, you know what? I'll give you 5 minutes or so in there. They'll give you 5 minutes or so.
5 minutes for what?
Well, based off the video, one video is at 11:12 and the next one's 11:23, so you actually gave him at least 11 minutes per video recording. So my thing is, when it stopped, he asked multiple times, I mean, why? Why did you not let him out? It's just a simple question.
To be honest with you, I mean...
Don't
Were you punishing him?
No. Just...
Well, that's what you're saying in the video.
This is what you got, this is what you make me feel like.
See, and then it's all backfired on me. Like, it's all backfired on me. And I understand the severity of this.
He's dead.
It's awful, I know.
Okay.
It's awful. And I will tell you both this right now, too. I will never drink alcohol again.
Okay.
Like, I will never drink alcohol again. I don't care what it is in any way, shape, or form.
But let's get back to this. What was the reason for leaving him when he's begging to be let out? I don't understand that.
What I have a feeling was, and again, it's the whole time frame thing. You all.
I'm not asking a time frame. I don't care about a time frame. He's in the bag saying, I can't.
My God.
And you say, fuck you.
For the whole few minutes that he was in there,
Minimum 11, but yes, go ahead. It's a few. 11. Minimum.
But one video.
I love how Detective K is just very nonchalant about it. Yeah, well, she goes a few. Detective K goes, well, 11. But she says it, she's very calm. I love it.
Well, in between those two videos.
Between the two videos? Okay.
Yeah.
So what's the question again?
When he's begging for his life, telling you he can't breathe, let me out, and you say, fuck you, why don't you just let him out? What are you trying to prove to him? There was obviously something in your head that you were thinking of when he was asking to be let out, and you're like, no,
again, it's the boy calling wolf.
Okay, but where does this game end? You say this is a game, you got
obviously
in there.
the wrong way.
Yeah, just a little bit.
So what was your intention for leaving him in there?
And it's not fair. It is not fair. You guys are trying to, again, he's in there. Night, night.
That's what happened.
No.
That's absolutely what happened.
Intentionally.
How's it not? You got up off the couch, walked up a flight of stairs, and got in your bed.
Thinking he was going to get out.
And he didn't, and you still didn't go down and check
And it's the
him.
whole 30-minute thing that you guys are trying
I don't
to
care
do,
about
whatever. For all I know, it's 10 minutes.
He's begging for his life, telling you he can't breathe.
I don't know what you want me to tell you. I don't. I didn't intentionally mean for this to happen.
You can't tell us why you left him in there and went upstairs. That's my only issue. What am I supposed to write? What do I write?
So my thing is, though, what I have a feeling is I went upstairs and just hit the bed kind of thing. But, again, I'm thinking, he'll be up here in a minute. But then I go out.
But my question is, why didn't you just let him out prior to going up?
I don't know why.
He's begging to be let out. He's not laughing. He's not having fun.
Right,
You said
I know. I don't
this
know.
was supposed to be fun. You were laughing before. Before you said he was laughing, you were laughing. You went upstairs. He had his fingers out of the bag and he was playing. Well, obviously that's not the case.
So are you guys, so what is it you're trying to, like,
We're just trying to figure out why.
Again, remember, she came in on her own with her stack of papers and her questions, which actually she got to ask a lot of them, including could she get the ring back that she bought for him. So tacky. But I don't think she looks at all like she feels threatened by them. I mean, she's being defensive, of course, now, but she's the one they just kind of let her talk. I mean, really, it was pretty easy for them. She just came in and started blathering on. She does not look like she feels like concerned about his firearm or anything of that nature.
why? What?
Why?
What was the motivation for leaving him in the bag?
Why he was left in the bag? Why the
I
video?
didn't have any motivation. It was he and I having a great day, fooling around, being stupid, and apparently me going upstairs and hitting the bed, not going to sleep, where it's like, I'm tired now, I'm going to go to sleep.
That's excluding, it's a good analogy for the day, excluding the fact that he's got a bump on the back of his head, a bump on the front of his head, and his lip is busted, and he has a
Oh my
bump on his
gosh.
eye.
I don't know what you all want me to tell you. Like, this is not fair at all,
Yes.
that you all are assuming that that's from me.
Where else did it come
If
from?
you were
She's so upset right now. Why wouldn't she say right now, I need an attorney? Why didn't she say it a long time ago? I just think she's so right in her rightness, if that makes sense. It just doesn't matter. She just it's, no, it's, I'm perfect. Nobody else is. Ugh. I can't with this woman. I can't.
say
Oops, sorry.
it's opposite, you were in the suitcase and you're asking to be let out, would you hope that that person would let you out? Like, you're asking to be let out of a suitcase, should they not let you out?
Eventually. I'm guessing. I mean,
Oh, Sarah.
I'm blaming it on the wine.
Blaming it on the wine.
So you guys are like assuming that,
You keep saying we're assuming, oh, we haven't assumed
Asking
anything.
questions.
but you guys are assuming that that's what I did.
See, she's putting words in her mouth. Now, maybe this part when her saying, it's the alcohol will help, but I don't think it does help. If in Florida, at least, I don't think the alcohol is any good reason. Nope.
No, by what,
Like, this is-
the facts of what happened. We got there, you said you pulled him out of the suitcase, you said you went up, you went to bed. We're not assuming that. These are the facts that you're telling us.
But
Now
what
we're
you said
asking
is
you
like,
to
oh, I'm
explain them.
tired. Oh, I'm tired.
Well, that's what you told me on a sworn recorded statement yesterday. Because when I said, oh, you went upstairs and passed out, you were like, no, I did not pass out. You got attitude with me because you were you
Yep.
thought I was assuming that you were drunk. So that's an assumption. That was an assumption when I said you passed out. And guess what? You corrected me.
You're very adamant about the fact that both of you had your wedding vows. What's your favorite word to use?
Compass mentis.
There's her word. Oh, one of normal intelligence.
You've used it today too, to say that you guys are within your wedge. There's two empty bottles of wine.
No, both. We didn't drink both of them.
I think you did.
We didn't.
There's receipts for the
They were
savings
both
factor.
purchased yesterday, so I don't know how you did, because they weren't there the day before.
So one
There's
was.
two Publix receipts from yesterday.
Mhm.
Only thing purchased on either one was a single bottle of wine, 2 of them. So we have each bottle of wine that was empty in your garbage can that you purchased yesterday, or he purchased, but you two would have consumed together.
Okay. Well,
I mean, there's receipts, so it's not even worth the going up.
So this is. So I don't know what you guys are. I don't know.
We were just hoping that we could figure out why you.
What was the motivation?
There was no motivation.
Well,
Well, we're watching a video that After talking to you, everything was laughing and fun. Now we're watching a video where it's not laughing and fun. He's begging for his life, and you are in a very angry voice telling him to fuck off.
No.
Yes,
Not.
that's absolutely what it was. It's not an assumption. The video's there. We played it for you.
So you guys think that I intentionally...
You got
doesn't matter what
off
It doesn't
and
matter
walked
what
up
we
the couch, or walked up the stairs and got into bed.
Don't you see? She's doing way too much talking. Why didn't she stop a long time ago? If she's so damn smart, why didn't she say, I need to talk to somebody? And there's a part in there, too, where she goes, I know how this works, you know, like the legal system. So she does understand it a little bit more. So, see, she can't be smart and then play dumb, which maybe she's somewhere in between. I don't know. She's just annoying, though.
That was intentional. There's no way getting around that. You intentionally did that. Nobody drug you up there. You didn't float up damn stairs.
Okay, well, it's not fair. It's not fair that you guys keep trying to say that that's what I did.
I don't know what to tell you.
You told us that. You didn't go upstairs?
Again, there was a hole in a suitcase.
Uh-oh, she's starting to get
I
rabid.
from the hole with one finger.
Well, the damn hole didn't do him no good, did it?
But he could push it open.
No, he
Did he?
couldn't. The video
No.
shows him pushing up.
And
If
then,
he could push it open, why wouldn't he have gotten out himself? Why would he beg you to open it?
because
Okay.
you can't breathe.
Okay.
If
I-
someone
I-
can do something for themselves, they're going to do it. They don't need assistance unless they need assistance.
So, but why would he start doing it?
Because he couldn't, because it was all the way zipped.
Didn't see it.
It wasn't.
Mm-hmm.
I intentionally didn't do it. That I intentionally did not do.
What's that? You intentionally do what?
Zip it all the way. He nor I,
Well, he's dead as a result
lay
of your
hands on
action.
each other.
He is dead as a result of
I
your
understand
action.
that.
So,
That's why
You
this.
two didn't lay hands on each other.
No. No. I don't have anything.
You're right.
He doesn't. Whatever that is, whatever this, whatever.
She
it
doesn't
is,
have any bruises on her. So would it have really been self-defense because he wasn't doing it? She doesn't have any marks on her.
happens. It's not fair that you
Yeah.
guys, just because he has those, automatically blame it on me.
See, those are her words, not theirs. She doesn't know when to shut up.
Like,
well, what about when you had your injuries and he gets arrested? Is that not fair?
really? Like, really?
Exact same thing.
Really?
He has injuries. You have injuries. Like, what does that mean?
I don't have any injuries.
Correct.
Because
Oh, this is bad, Sarah. Very bad.
he and I have not been at it with one another.
So every time that you guys fight, you both hit each other? So you should have probably
No.
gone to jail all those times that he went to jail
No.
for domestic?
Well, the one time I did. But he completely trashed the police report. Because that's nothing what happened. Because the reason why I got taken in was because my story was different than his.
Of course. Okay, I've heard enough of this. But see, she's just all over the place, flip-flopping and all that kind of stuff. But I just wanted to replay some of that so we could think about these things when she's going into court and, you know, when the witnesses come forth. And it's very interesting. This should be, unfortunately, quite a circus. But I guess that's enough. I just wanted to share some of that because I always like to revisit things to see how this is going to play in court when it all begins. So tomorrow, I guess, it's jury selection, I think, how that's all going to start. But at this point, we're there. We're there. It's going to happen. It's starting tomorrow. Whenever you go get this. I can't promise it's today. This is the, whatever date this is. Anyhow, I think it's the 6th today. Anyhow, I hope this brought something to you all to think about when this all begins and we finally, hopefully, pray we get justice for George and his family. So, thank you all so much for watching, commenting, subscribing. And if you haven't subscribed yet, please subscribe. It doesn't cost a thing. I really and truly do appreciate each and every one of you all. I love you. Be kind to someone. Be kind to you. And I'll see you the next time.